So hi everyone and welcome to ICARE's Litigating and Legislating for Animal Rights seminar series. I'm delighted to see so many of you joining us from around the world. I am personally from Brazil. I'm speaking right now from São Paulo. So we are here at our third seminar where we continue to explore how law can become an effective instrument for recognizing and enforcing the rights of non-human animals. So I'll be your new moderator for this series. So this is my first time with you guys. I'm very excited to be here. I really appreciate Maureen's invitation to be a part of this. I've been following ICARE's work closely and so many amazing courses and events. And of course, it's such a great opportunity to be here with Christopher Berry. And well, for those of you who don't know me, my name is Anna Caramuru Aubert. I have a PhD in law from the Federal University of Rio de Janeiro and from the University of Münster in Germany. Today's discussion, the judicial psychology of paradigm shifts in animal rights cases, invites us to look beyond black letter law and examine how judges perceive, process, and respond to claims for non-human rights and how those perceptions evolve over time. So a very, very interesting and important topic. And I am truly honored to welcome our guest, Christopher Berry, the Executive Director of the Nonhuman Rights Project, the first and only organization in the United States dedicated to securing fundamental legal rights for non-human animals through strategic litigation, advocacy, and education. Under his leadership, the Nonhuman Rights Project continues its pioneering work to challenge the legal status of animals as property and to open new frontiers for rights-based protection. Christopher, thank you for joining us. Before we dive into the conversation, perhaps you could start by telling us a little bit more about your background and about the Nonhuman Rights Project's current work and mission.
Well, thank you for having me. I love ICARE and I love all of your work, and I'm super honored for everyone who's attending and who's going to watch this later. Like, I think it's really inspiring that so many people are, well, inspired to try to protect non-human animals because I think, through the legal system, it's advocacy, and animals can't advocate for themselves without us. So I think that's really great. But yeah, my name is Christopher Berry. I'm, based in the United States. I have been practicing law for around 14 years and have been doing animal related litigation and legal work for my entire career. Before I joined the Nonhuman Rights Project, I was at the Animal Legal Defense Fund, and I specialized in I kind of gravitated towards litigation where we were just trying to get the law enforced on behalf of animals, right? Like, and that's like a lot easier said than done because animals, they don't have legal standing, and we don't really give them a right to enforce their protections. So you're really just really we're at the mercy of the government for the most part. And that's really what opened my eyes to this idea that animal legal status was right. It's not just that we have all these laws that aren't protecting animals. And so my realization, sort of working, I guess, as we might say, like within the current paradigm, was that it's not working, that it's not working for animals. And so now I'm at the Nonhuman Rights Project, and the mission of the Nonhuman Rights Project is to secure fundamental legal rights for non-human animals. And we do that through like sophisticated legal advocacy, litigation, legislation, kind of government relations work, and education and public outreach. So that's a little bit about me and a little bit about the NhRP.
Okay, thank you, Christopher. Yeah, in Brazil, the Nonhuman Rights Project is a true reference for us in our own attempts to litigate animal rights. Currently, I don't know if you've heard of this, but we've had some recent decisions in which judges accepted animals as plaintiffs, right? So we do have at least dogs, right, have been accepted as plaintiffs. And I think a lot of that is due to how you guys have started this, just getting that first door open so that other initiatives could be taken worldwide. And I think our conversation is going to be a little bit about that, about how what you're doing there can influence everyone everywhere. And so our seminar today, as you know, is about judicial psychology of paradigm shifts. So maybe you could unpack what we mean by judicial psychology in this context, right? So how does understanding the way judges think and decide cases help us grasp the challenges and opportunities for animal rights litigation?
Yeah, so I want to give like a disclaimer before I answer that, and really the disclaimer applies kind of all around, which is like I'm not a psychology researcher, right? So a lot of my insight that I'll be sharing is based on my 14 years of practical experience observing and interacting with judges and trying to push the envelope. So I just want to get that out of the way. And it's an informed view as well. Like I've read stuff and I've been thinking a lot about this. I actually think this is an underserved area of study in general. I was at the FAIR, that's the Psychology of Human and Animal Interrelations organization. It's psychologists who are interested in animal advocacy. And I went to their conference this year with the intended purpose of trying to like understand and inspire people to sort of think about this area more, which is decision maker psychology. So that's the disclaimer. I haven't even answered your question yet. So you had asked how do we kind of understand the way that judges think? And like the short answer really is like legal analyses happen in our brains, right? They happen, as far as we know, they happen inside our brains. Like it is a psychological process, and there is right there's different sort of like variables that are relevant there, right? Like judges are going to have they'll be thinking like pragmatically, like if I do this, then what's going to happen? Like how is the public going to react? How are other courts going to react? How, the higher court, how is the legislature going to react? They'll be thinking about their professional reputation, right? Like, and that it may just be the reputation is valuable itself, but if it's a judge who gets elected, they'll be thinking about, that they may be thinking about re-election. They bring their own personal experience and perspectives, right? Like, and we can call those sort of biases. In a way, it's hard to for anyone to totally discount their own personal experience and how they perceive and think about the world. So, yeah, so that's really kind of like what we're thinking about there. And understanding this psychology, I think, helps us to understand like what barriers are in our way, like why we may not be making progress, but also to help understand pathways to what, right? If we understand these like motivations and the psychology and how the system is thinking and operating and what's incentivizing it, that can open doors and help us avoid closed doors.
Thank you, Christopher. Yes, I also have this interdisciplinary background, so we are always scared of making claims about other fields, but I think you have such an important experience to share. And yeah, definitely that's a very important aspect, I think, of the Nonhuman Rights Project's work. So I appreciate your answer. So I guess the Non-Human Rights Project's work explicitly tries to provoke a paradigm shift, right, in the legal status of animals, from property to rights holders, which of course for us that seems so obvious, right? But it's not for most people. So from your experience, what makes paradigm shifts in law particularly psychologically complex for judges compared to those incremental doctrinal changes?
Yeah, I think that's a great question. And the first thing I would say to it is that psychology plays a role in whether we even see this as a paradigm shift in the first place, right? So I would push back on the characterization that this necessarily is a paradigm shift. And so what I mean by that is, so like in the United States, for example, the Nonhuman Rights Project is best known for for our habeas corpus litigation. It's based under American common law. That's really sort of traces back to English common law, which has had a huge influence on the law of, kind of across the globe. And so what is habeas corpus? It's common law. It's saying judges have the power to protect individuals from unlawful or unjustified confinements. And we're saying, well, this chimpanzee is an individual who's being unjustly confined, and you, the court, has the power to do something about it. Not actually the power, but you have to do something about it. And you have to think about chimpanzees, in sort of in a post Jane Goodall world where we know that chimpanzees have personalities and these advanced minds, rather than the world of 17th century world of René Descartes, right, who viewed animals as unthinking automatons. And so in from one perspective, and this actually happens to be my perspective, there's no paradigm shift at all. Like, we're actually just trying to make sure the paradigm that already exists is operating at maximum efficiency. So anyways, I think that's really important. But in terms of like what's holding judges back, I think I was sort of alluding to these earlier about like the different potential barriers, and um, I think, in my opinion, sort of the best view is that judges are pragmatists, right, who are doing their best to interpret the law, but doing so with a sort of pragmatic understanding or a pragmatic bent, and then of course doing through their own sort of personal experience and like what we might call biases. And so I think that ultimately that's the barrier there, like sort of a fear of how this, like, they're going to touch the stove when it's too hot and burn themselves, perhaps. Or maybe just bringing a bias with them that non-human animals are distinct and therefore can just be categorically treated differently.
Perfect. And I love how you approach this idea of a paradigm shift. I agree with you. And yeah, when we think about great apes, that's just so obvious, right? We are trying to do that with all the other animals. And although, again, for us, it seems so obvious, for so many people, it's just not. But yeah, very interesting. So on that note, do you see parallels between the judicial journey toward recognizing animal rights and earlier moments of transformative change in law? For instance, in cases about slavery, women's rights, or environmental personhood. And well, it's interesting. I was talking about this the other day with my grandmother, actually, who's been a vegetarian for like 60 years. And she was also one of the first women lawyers here in Brazil. And she was always bothered by that article we have in our constitution: everybody is equal before the law. And when she was growing up, she didn't have the same rights as men, right? And she was not equal before the law. And she pointed out how currently animals aren't either, right? But we've been seeing progress in other fields, other struggles. So how do you see that?
Yeah, I think this is like a sort of classic and well-known phenomenon in what we might broadly call like a social justice movement, or I guess really any kind of like legal or civil rights type movement, which is sort of I don't know, like what appears to be like a status quo bias, something along those lines, that over time with with a persuasive argument, a kind of a shift in cultural attitude and kind of enough sustained energy that we can see that status quo bias erode over time. And so this is a very classic sort of arc of change for social justice movements. And I would I think a really great way to capture this would be to compare and contrast uh, two opinions. And I think it'd be great if someone did commentary on this. So if there's any law students or practitioners out there who are inspired by this, consider writing like a note or a comment or and publishing an analysis on this. So in 1971, I believe, the Minnesota Supreme Court decided a marriage equality case. Like two men had sued, claiming that they had a constitutional right to marry, regardless of the fact that they were the same sex. And the Minnesota Supreme Court said no. and the structure of its reasoning, it essentially just started off with looking at open a dictionary, right, and said, well, plaintiffs, like, you didn't look at this thing called the dictionary, and it clearly says marriage is between a man and a woman, and it cited the Webster's Dictionary and Black's Law Dictionary, and it was like, and then it said, we can't do anything about it. Like, we're the court, this is a civil liberty constitutional claim you're making, but like, we just can't do anything because of what Webster's says. And then at the very end, they're like, but we're not heartless. Like, you could go to the legislature if you wanted to. And so fast forward now, 2025, Nonhuman Rights Project case against the Cheyenne Mountain Zoo, Colorado Supreme Court, literally the exact same structure in its decision. So it starts off with the exact same dictionaries, Webster and Black's Law. It says we can't do anything about it, even though it's a civil rights issue that courts are supposed to do stuff on. But then it ends by saying, like, you can go to the legislature if you want. So there's like this, like, those two side by side have parallel structure in a lot of different ways. And yeah, and of course we all know what happened with marriage equality kind of worldwide and in the United States in particular. Like, in fact, it did become a constitutional recognized civil liberty, right? So it just shows that these things can and do change over time.
Perfect. Very interesting. Very interesting. The Non-Human Rights Project's litigation strategy can be described as a form of exposure therapy for the judiciary, thus gradually familiarizing judges with the idea of animal personhood and fundamental rights. Could you perhaps explain this concept and how it has guided your case strategy?
Oh, yeah. So I think that's like a kind of clever way of describing it. I wouldn't say it's necessarily like guiding our strategy, but I do think you can view what we're doing in that way. And that's because so for people who are unfamiliar, exposure therapy is if you have let's say you have a phobia of ants, you'll be sort of incrementally exposed to an ant, and it'll, with the intent of having your phobic reaction decay, right? So they might show you kind of like a crudely, like a children's crayon sketch of an ant, and then escalate to like a stuffed animal ant, and then eventually like maybe work up to like an actual ant, and then that it sort of gets the fear out of your system. But like, why I think this can be a useful concept for thinking about our work is because, like, I see a knee-jerk reaction against non-human animals, having the status of like a person or like a rights holder. I see that knee-jerk reaction when we bring our cases, and something that I think is really strategically valuable is, like, even when we lose, right? Even when you lose this claim with non-human rights or whoever, you're you're challenging the system, right? You're presenting like a better argument, and because it's a better argument and there's a knee-jerk kind of reaction against you, it causes the system to like generate an opinion or a justification for the status quo that actually doesn't quite make sense. And there are some like actually really like glaringly obvious logical fallacies that I've been seeing in decisions against the Non-Human Rights Project in particular, like circular reasoning. Humans are protected by habeas corpus because humans have fundamental legal rights, right? That's circular reasoning. And courts are kind of latching onto that, and we can expose it, talk about it, right? And that's part of this like conversation and movement over time.
Okay, perfect. Thank you. I have one more question on those lines, right? So considering again this topic of exposure therapy, I loved your example about the end. Do you think that in the courtroom, there are moments when a judge's framing of a case subtly changes? So for instance, in their language about animals, so even if the outcome legally remains the same, maybe you see a shift in how animals are referred to.
Yeah. So I don't see this through the course of a case so much. Although I will note that even when judges rule against us, I see a lot of this kind of disclaimer language about how magnificent and beautiful and amazing and impressive our clients are, right? Elephants are so like majestic and amazing, but they're suffering brain damage from the lackluster enrichment in captivity. Can't do anything about it, sorry, right? Like there's something that's kind of interesting about that to me. But I don't see that judge sort of changing over time. Maybe I personally haven't noticed it. Maybe it happens and I haven't detected it. But what I have seen and what is, I think, really interesting here is that that we have some evidence of judges moving like over the years after being presented with multiple cases. So the best example for this is New York, where the Nonhuman Rights Project started filing. I think our first case was 2013. Um, and some cases, like we went up to the New York Court of Appeal. We asked them to review. That's the highest court in New York after our first wave of losses in the early 2010s. They said no. Well, we went up a second time. There was like kind of a second wave of litigation there. And in 2018, one of the judges who said no to us the first time, this is Judge Eugene Fahey, wrote a concurrence in 2018 in Tommy and Kiko's case, where he's like, where he expressed regret and said, I think we should have taken the case probably the first time. We can't do it this time because it's like the same clients. I don't think that the claims are different enough. So procedurally, we can't take it. But then he wrote this lengthy concurrence that was like really groundbreaking, where he said, it doesn't matter that they don't have like legal duties. Like we give legal rights to like, children, for example, even though they don't have the capacity to obey the law. So he said like that our arguments for that have been using as a non-human rights project, they don't resonate with me anymore. And that was the second time. Well, he retired, but there were two people on the bench then who didn't do concurrences with him in 2018. But there were two judges who ended up writing dissents in Happy's case when that went up to the New York Court of Appeal a couple years later after that. So you can see there that there was this, initially we were iced out of the New York Court of Appeal, but one person or possibly three people, kind of up to three people were like when they sat with it, they were ultimately persuaded.
That's amazing to hear. That's very interesting. Yeah, very interesting. So how do you decide which jurisdictions, judges, or cases might be more receptive to this? We've been calling exposure approach. So what factors, legal, cultural, or psychological influence where and how the Non-Human Rights Project brings its cases?
Yeah, so I think the most important factor is actually just like, I know we're talking about like how people think and the sort of room to navigate around that, but the most important one actually just is the law, right? Like it's like first and foremost, like there's kind of our objective assessment of the law, and so that's like the primary criteria for where we bring our cases. Um, but and I think beyond that, there's a sort of cultural or psychological like component. Without having heard from a judge directly on the high court about our cases, like we can only really hazard to guess based on maybe indicators in the culture itself. So the one book I would recommend would be Cass Sunstein, How Change Happens, and he talks about kind of like norm cascades, how an idea might start with like one person out on a limb who thinks like I'm going to advocate for this idea, and then but more and more people can go over, and you can sort of start to reach a like kind of a cascade where people who hadn't thought about it or were maybe kind of scared of taking a position, like when they see more and more people, then they may join that cause as well. And so I think having in mind like sort of public opinion and legal culture is also important. And there are some indicators you can look at, right? Like, is this kind of a generally progressive state? What else has sort of been legally done with regards to animals? So those are those are sort of important factors to kind of keep in mind as well, potentially. But at the end of the day, like what the law actually says, I think is, that remains to be the most important thing.
Perfect. But like we discussed, sometimes the law says something, but right, it's interpreted in many different ways. So yeah. How do you balance, starting from what you just said, how do you balance appealing to this reasoned legal argument, right? So precedent, constitutional principles, comparative law, with acknowledging the emotional and moral dimensions that inevitably shape judicial perception of animal rights?
Yeah, so maybe it's sort of just reiterating the point that the highest priority is always the legal argument, because that even psychologically, like that is what judges care about. Like they do, even if there can be like skews in how they see it and how they and so forth, that's still the most important thing. So beyond that, right, there's I it is important to keep in mind sort of like emotional resonance, um sort of kind of like what we were just talking about with regards to like political support, like what's the culture, what's the public support in a given jurisdiction. So and then and then thinking through and presenting it to the much as much as you possibly can, right? What's going to be kind of morally and politically resonant as well. So that's yeah, I mean, there's just so many different like factors there, right? Like once you get past the sort of like legal limitations and wanting to have like a solid legal argument, that whatever's going to resonate emotionally, politically, morally, and however we can package that. So that's sort of I think the framework.
Perfect. So again, starting from that point, do you think it is possible or perhaps even desirable for judicial education to address the psychological factors more explicitly? So, for instance, through seminars, continuing education, judicial dialogues about animals and law. So, what's your take on that?
Yes, like a million percent yes. I think this is actually really I'm really interested in this intervention. It's like yeah, it's sort of education for the legal community, and potentially, yeah, and of course lawyers become judges, right? And then for the judges themselves too, because there are like sort of legal community networks and associations as well, and something that is like really a common theme for legal kind of like education and legal events is this idea of like bias in the law, right? Like we want to reduce bias in the law. We don't want prejudice, right? And so unfortunately, like it seems to me what's going on with non-human animals is an actual just like literal prejudice, right? And that's like it's a strong word to use. At least in the United States, maybe it's sort of more technically used elsewhere. I don't know the cultures everywhere else, but it's literally prejudice. So I was talking about the Cheyenne Mountain Zoo opinion earlier. Their ruling was animals, like the courts don't have jurisdiction to hear the animal claims, because the animals aren't like persons under some procedural statute that didn't even really have to apply actually. But that means that the court didn't even consider the merits of their claim. Like, were the elephants at the Cheyenne Mountain Zoo being wrongfully confined? And that is prejudice because you're saying like it's like before you even get to the question of like what's the justice in this case, you're prejudging it and you're saying they're elephants. So I don't like we don't have anything to say about it because they're elephants. This could be the worst situation in the world. They could be the smartest individual. These could be the smartest five beings in the entire universe, and they could be suffering more than the rest of the universe combined. And we don't and as a court, we cannot and will not say anything about it because they're elephants, right? Like that is just prejudice. And so, yeah, I think that that's an important angle. And how can we sort of like what would be an effective way, and I don't know the answer to this, what would be an effective way of um, inspiring judges to look at that differently, or inspiring the sort of the public and the legal community as well.
Yeah, that's perfect. I think ICARE, right, is trying to do something about it through these events and courses and seminars, because that's exactly what you said. I know it's a strong affirmation, but I completely agree with you. Yeah.
Music to my
Um,
ears.
Yeah, it's not often. So, the Non-Human Rights Project's litigation, of course, has been groundbreaking in the United States. And like I said, it inspired Brazil a lot too. And we've also had our history with habeas corpus, right? With Eron Godilho, for instance. But judicial psychology may vary across legal cultures, of course. So, how might the insights you've gained translate or not translate to other jurisdictions, do you think?
Yeah, that's a good question. I'm so immersed in this in the sort of US legal culture that it's very difficult very difficult for me to say, it's we're 100% the same or 90 or 50%. What what just because it's the sort of the nature of culture is that it can really impact your psychology and like what you're bringing to the case. There are, other cultures like sort of non like Western, like non-Latin based, non-common law based systems that have recognized like an important legal status for non-human animals, or for the environment as well. So like I think that's important, like that in other cultures, this you know idea that animals like don't matter, like that would be considered a radical paradigm shift from certain perspectives. So I think I was sort of thinking, like, how could I actually answer that question in like a non-annoying way? And I think it just kind of boils down to, this sort of like kind of an irony that, right, like in our litigation, we're talking about how similar non-human animals are to humans. And sometimes it's kind of easy to lose sight of the fact that like humans are actually, that we're animals too, actually, right? And why that's important is that we're reward seeking, right? Like that's really sort of our, like we take breaths of oxygen because it feels good, and if we hold our breath, it starts to feel bad, and that's why we eat food. Like so many of the things we do are just sort of are reward seeking behaviors. And I think that it will be true no matter the culture, right? But what produces a kind of reward response, or like a pain response, is going to be, uh, I think that's the kind of the wild card. And not only between cultures, but also like for individual sort of judges, or just individuals within each culture, like they're also going to have a sort of different profile there as well.
Perfect. I remember just now because you mentioned Cass Sunstein and his idea of nudges, right? So, yeah, that totally makes sense.
Mhm.
So, in systems with constitutional animal protection clauses, there's Germany, Switzerland, Ecuador, and Brazil. So, do you think judges face similar psychological barriers to paradigm change, or does constitutional language mitigate some resistance?
Um, So I think so. I think so. And I have two like kind of observations in response to that question. One, that there's kind of this like, what comes first, the chicken or the egg, right? So if you have legal authorities that are recognizing this enhanced legal status for animals, is that having an effect on culture, or does that only exist because the culture kind of allowed for it in the first place, right? That's sort of the answer is probably both, right? I think there's a nice sort of feedback relationship between the two. And then the second observation I'll make is I'll plug another book that I found really interesting. It's by David Cole. It's called Engines of Liberty. and he's a I think former legal director for the ACLU, and talks about change for civil liberties in the American context, for marriage equality, the right to bear arms, right, which was a judge-led civil liberties uh, um, movement, and then also habeas corpus for detainees in the war on terror. So he kind of tracks all of those. And what was interesting in the marriage equality example, is that, like, he observed, or that, and advocates had observed that, that judges, or that a state was ripe for movement within the marriage equality context when they, let's see here, when sort of a few factors kind of aligned. So the anti-sodomy laws became like decriminalized. So sodomy was decriminalized. LGBT uh, individuals were granted some like protection under anti-discrimination laws in the state, and then also that the state had made some effort to provide um, some sort of spousal like benefits for same-sex couples. And once those factors aligned, the state was kind of like, the pattern was like, that's when a state was kind of ripe for ruling in favor of marriage equality. And I think this was actually, those factors actually were not just confined to the United States. Actually, I think they had been observed maybe in Europe first, and then American advocates kind of latched onto those factors as well here. So anyways, that it just goes to show that, like, that these things do work in tandem, and that there can be a feedback loop that's generated between like culture and law.
So on that note of this effect different systems may have on each other, do you see potential for collaboration across borders? So maybe this transnational exposure therapy effect, as courts begin to cite or reference each other's reasoning, specifically here on animal sentience, animal rights, or legal personhood?
Yeah. So my answer to that is that, yeah, I think there is a kind of cross-jurisdictional impact. But the magnitude of it I think it really sort of varies depending on the sort of like the legal culture, or the psychology of the sort of whoever's hearing the case. Um, in the United States is kind of like pridefully nationalistic in a lot of ways, where a lot of times they'll say, like, we don't really care what's happening in other countries, right? But on the other hand, sometimes judges will cite trends in other cases, and I think sometimes you might be aware of that, and that can sort of add to the, I don't know, uh like the courage, right? Or it can help to erode um some of the shyness or hesitation that a judge might be feeling, to because they're getting they're getting an indicator, or many indicators, that this is an idea that reasonable people are sort of coming to as well. So I think maybe it's, yeah, partly going to be on the sort of how much does the system care about law developments in other jurisdictions, but also like how how motivated is the judge in the case to kind of like, I don't know, stretch a little bit and rule push the envelope, versus like maybe they're just hostile to you, so they're going to like just totally discount that other precedent.
Perfect. And that's so important, right? When we think about how connected everything we're talking about is to climate change and to things that affect the whole world, right? So here we've been having so many issues with the Amazon, right? And how important is the Amazon for every other country? And so, yeah, these initiatives, I think they are kind of required, right? But if we think about the next decade, what kinds of cases or arguments might best help to move judges from this cognitive dissonance or this prejudice, right, toward moral and legal acceptance of animal rights? Do you have an answer for that?
Well, that's if it's sort of like what is going to win, I guess that's like the $1 million question, right? So or maybe 10 or 100 million, I would say probably worth it for the animals. So I mean definitely worth it. So um my starting point would be um yeah, at least from my vantage point, like what the Non-Human Rights Project is doing is I think is like a really it's a sound argument, right? So that would be my starting point. And we've seen progress happen already, like that in the New York sort of trilogy, like the three waves of litigation in New York that culminated in no Court of Appeal judges, high court judges agreeing with us to one and then to two, right? Like that's a very, linear growth over successive waves of litigation over 9 years in one state. So like, um, so anyways, if we do that, we'll grow more support, right? But the question I think is going to be, what is there ways to do it, like faster, or is there another like a complementary angle that advocates could be going at here? Um, and yeah, I don't know. I think being, smart, detecting, like looking for evidence of what's going to work, and then like being flexible and including that in our strategy is going to be really important and effective. So like the Non-Human Rights Project, we've done like a public survey, at least in the United States, and it's not public yet, but keep follow us on social media at Non-Human Rights. And you'll should find out about it at some point. But the initial some of the initial findings showed that like what people care about, like what arguments are resonating with them, right? And what resonates with people are sort of the idea of animals in like natural conditions, and like being well treated, humanely treated, not being abused, right? So those sort of like welfare concerns, which is kind of awkward from a rights perspective, but that is indicating, like, in terms of like what's going to be emotionally or politically resonant, like that to me, that's an indicator that sort of framing even like rights laws in that language and with that framework is going to be, seems like it could be effective, right? So that's just one example. Maybe there's reasons why, maybe there's other data that I haven't thought about that sort of contradict that in some ways. But I guess the point is to always, I think, be thinking empirically and to really sharpen our approach. So
Perfect. Yeah, very interesting. I've recently read also that people tend to be more compassionate to or empathetic towards animals who are similar in terms of intelligence more than in terms of appearance or having similar.
hmm.
Yeah, so we keep trying to find those. Even if we are not concerned with that in particular ourselves, how to best, yeah, make that change in people's minds. So beyond the courtroom, what role can legal educators, NGOs, and policymakers play in fostering the psychological readiness of judges and legal systems to engage with animal rights as a serious legal question?
Yeah. Um, Yeah, I think that sort of goes back to what we were talking about a little earlier with regards to like how could we get sort of judges to be thinking about this differently. And so this comes down to like kind of like education and communications, right? That sort of outside of the courtroom outreach, which in some ways kind of is. Sometimes I think about this as like just litigating outside of the courtroom, but instead of doing it for a judge, it's sort of like a community or a body, right? Like they're the ones casting judgment on you, and so like how do you present your case? Like through what procedures can you use to get noticed, right? Like trying to generate like a headline or getting on certain audiences like favorite podcasts or something like that. So definitely thinking about that from an education and communications lens, and then within that, there's like a subset too, right? Where you have like, there's all these sort of like different ways you can break up the audience. So you have like the public at large, which is important because in a democracy, especially. And then you have like law students, and they have their kind of legal curriculum and those sort of channels. You have like practicing lawyers, and they have like like kind of lawyer associations and events, like even non-animal ones. I think it'd be important to like talk to non-animal kind of practicing lawyers about how this intersects with their work. And then of course, like judges themselves, they have their own sort of networks and conferences and systems as well. So, plugging in there and then figuring out what's the right messages to convey, right? So if I was kind of like directing or advising the movement, I would have people be sort of thinking about and coordinating and consulting with each other on, if to the extent that we are getting into these channels, right, and we're able to talk, like what are kind of like some of the least common denominator issues, right? Like what are issues that kind of cut in common for all, kind of for all issues. And what can we be saying? Like what's an effective message or an effective educational piece that's going to boost, not just like my sub issue, but kind of like the movement as a whole, right? Like the cause as a whole.
Perfect. Again, the work ICARE has been trying to do, right, is so important. In Brazil, we have, you mentioned like associations. I used to be a part of this very nice Animal Rights Lawyers Association. It's nation-based. So Gisele Shen is currently its president. And they're really tirelessly trying to litigate for animals in a country that is very meat-based. And yeah, so I think you're completely right. And of course, your work with the Nonhuman Rights Project and everything is so connected. So from your perspective, what does a judicial paradigm shift look like in practice? So how will we know? I mean, you say you don't even think of it as a paradigm shift, perhaps, but how will we know when this change, at least in the perspective of judges, right, has truly
Hmm.
occurred? So not just in so many law books, but in judicial consciousness.
Yeah. By the way, I love iCare's sort of work in the like in this educating space. I've been really impressed. It's like so I just wanted to say that because you mentioned some of the stuff that iCare is doing. So we got a heart for that. Okay, so what does a judicial paradigm shift look like? Well, okay, this is going to be so Richard Posner uh or Posner uh uh has a book called How Judges Think, right? So he's a now retired Court of Appeal judge from the United States, but he wrote like a whole book about how judges think, and really kind of like a common thread in that book was that judges are like practical, like they're pragmatic thinkers, right? So they're sort of not sort of just like kind of naively ruling on the law, but they are thinking through like the sort of practical and political kind of ramifications of various rulings and kind of like just trying to like mediate all of that. So why do I mention that? It's well, because I think he's right. That even for judges who agree or are sympathetic, I think there's for better or worse, I think they're going to act incrementally and pragmatically. So the answer to your question then, with that sort of in mind, is I th I think we're not I think we may not really notice the paradigm shift happening. So what does it look like? It's something that I think we may not notice starkly. And in fact, I think we're actually already undergoing that paradigm shift. So there's like this I have this idea that I want to write on, or maybe someone else has already written on it, and you could please share that with me, if anyone who's watching. But I call it like shadow personhood or shadow standing. And it's these ways in which judges are actually already treating animals like they're legal persons, like they already are, and they're just like refusing to say it. Like sometimes like really like like quite explicitly just saying like we decline to say that they're persons in this case. So like there was a one from 1998 called like in Ray Fouts Trust. So this was like a pet trust that was created for chimpanzees that were Roger Fouts had like trained to do sign language. And Animal Legal Defense Fund, I believe, brought the case, and there was some trust issue that was raised, and what they really wanted the court to do was to like say that and that these chimps being beneficiaries of a pet trust, like that made them legal persons, like at least with respect to like having like a property right in the trust, which I think is just actually just a plainly true view. If you have a beneficial interest and a trustee can enforce that on your behalf in court, that your trustee has standing to do that on your behalf in court, like no doubt, like in my mind, that is a very sort of basic, but it is a form of legal personhood. And the court just said, we don't have to say personhood to resolve the case, and we're not going to. There's another kind of line of cases about whether in the United States you need a search warrant to go into someone's house to look for evidence of crimes. But if there's exigent circumstances, the police do not need a search warrant, right? They can just like, let's say a person is being seriously injured, right? Like they can just come in and provide aid to that person. Um, and and there's this question of like, well, what if they're trying to save an animal who's being like abused or neglected or dying? And courts have ruled that animals are sort of validly fit within that exception, even though the word person is used. And then they reformulate it so they don't use the word person. They're like, well, an individual or like a being, right? So we're not going to use the P word. But they do that. And then there's, I could just go on. There's a few more. There's like animals as victims for purposes of like sentence mergers. Um, guardian ad litems have been appointed on behalf of animals. Like, in like a dog fighting case, for example, for like what should happen to these dogs. Um, in, injunctive remedies to help animals. So like if a human brings a case because they've been aesthetically injured, right? Like they go to like there's a human injury because it's like a visual nuisance for them when they go to the zoo or something that they see the animal suffering. Like this is kind of part of the playbook, at least in the United States, for how to bring a case on behalf of an animal is you frame it as a human injury, but then the judges are awarding like relief and remedies that protect the animal, right? Like rather than like the zoo has to put up a curtain whenever this person visits the zoo so that they don't have to see the animal being abused. They say stop abusing the animal, right? So there's kind of this mismatch between who's bringing the case and like what like whose injury is a predicate of the case and whose injury the court is remedying at the end of the day. So like there's anyways, this is like very long, but my point is like we're already going through this paradigm shift right now. And I actually think people if we step back, I think we can sort of appreciate that. And it's happening very incrementally and subtly.
Ah, that's so interesting. I love that concept of this shadow personhood. I remembered Visa Kurki's work on legal personhood, and I don't know if you've read it. He has a very detailed book, right, on the evolution of the concept of legal personhood and how those different incidents of personhood, right, like it's just being able to act as a plaintiff or owning property and the differences between being a legal subject and a legal person and how subtle that can be in terms of analyzing who is already a person, who is not, what's lacking for that to happen. And it's a very interesting book, I would say, on this topic. And I think it has some features in common with what you just said. So if you, Christopher, could redesign a judicial training or mentorship program for future judges, what would it include to cultivate openness to the evolving moral and legal status of non-human animals?
Yeah, that's such a great question. Um, I feel like if I had like unlimited time and like didn't have to like manage an organization, this would be a thing that actually I would love to just like drill down on and to spend so much of my time figuring out because and also sort of figuring out how effective it would be. So I would say that my this might be kind of an unsatisfying answer, but something that has been like empirically tested, um, for to measure the sort of impact on like, where you would measure their bias ahead of time, have some sort of educational intervention, and then measure the bias afterwards. Keeping in mind also that I think it might sometimes take a few years for the idea to kind of percolate, right? Because we saw that that's kind of what happened in New York, for example, when the judges kind of started flipping more to our side over time, which is I think they kind of got exposed to it, like experienced and lived the world for a few years, and then those ideas kind of like changed, and that actually resonates with like me, like, like I stopped eating animals, and that was like because I had watched a video once, but I didn't stop right away. It took a few years, and then actually at one point I was like making pork chops, and it like the grease in the frying pan sounded like pig squealing, and I was like, that's it. Like that was the last time I ever made meat. I ever ate meat, and it took a few years from watching PETA's Meet Your Meat to that experience before I actually stopped. So, anyways, the point is like being like sort of doing empirical testing on like what educational intervention, so the extent that we can. And there's like some great groups that kind of are in this space too. So like I don't know if people are familiar with Phonalytics. I think they're an excellent nonprofit, and I've like thought about like trying to like pitch or like convince them to do something like this actually with the Nonhuman Rights Project. But I do think that there's some space for that. Now, if I was going to give a more if I was just going to like shoot from the hip and guess like what might work, a couple ideas could be like um there's uh one of the formative books in my journey was called The Great Ape Project. It's a collection of essays about great ape rights from the 90s. And I think it was Richard Dawkins, his essay started with this idea. It was like this letter of like we have to like save the aardvarks, right? Like, aardvarks are suffering, um, like they're dying, like we need to like do everything we can to save them. And then he's like, people would be like, well, what's so special about aardvarks, right? Like it kind of begs that question. But if you do the same thing with like humans, right? Like human children or something, people like no one questions that. They're not like, well, what's so special about human children? Like we just know that they're special. And it's not to like that's not to like degrade the importance of human children at all, but it's sort of to say like there's a bias going on there, right? So I think like something like that could be a way of kind of demonstrating or making that visceral for judges or people who do this curriculum. And then one other thing that I would think about too, like again shooting from the hip, I don't know how effective it would be like doing case studies of non-human rights project opinions. So I mentioned earlier, there's like circular reasoning. So in the Happy decision, they're like, well, the Non-Human Rights Project claims that because elephants are so like intelligent and cognitively complex and autonomous, like that they have a liberty interest, right? That deserves being protected by habeas corpus. And they're like, but silly Non-Human Rights Project, habeas corpus protects humans because humans are have fundamental rights, right? So like humans have rights because humans have rights. Like that was the reasoning. And what was interesting about it too is actually when they did that line, right? Like we were like the whole point of our case, the whole reason we submitted hundreds of pages and got all these experts, right? Um, to opine. The whole reason we did that is because we really wanted you to drill down and give us an answer. Like, why is their intelligence, like, why is their experience and their suffering, like, why does that not matter to you? Because that's the thing that matters. And they dismissed all of it. The whole point of the litigation, they dismissed it by saying humans have rights because humans have rights. And then what's almost funny to me, if this hadn't been like denying someone their liberties, which was a total injustice. But what was almost funny about it to me is they emphasized the word because. So they said essentially it was humans have rights because humans have rights, um, which was just like emphasizing it doesn't make the argument any stronger, right? It actually just to me it was like a red flag and then like a disco ball hanging over it that like this was not a good argument. But that's why Happy is suffering in the Bronx Zoo right now and wasting away instead of living out the rest of her life in a sanctuary, is because humans have rights because humans have rights. So that's your justice system, you know. Maybe exploring that with with judges or other people, maybe that would be an effective intervention as well, because like I have been saying all along, like I think judges actually, first and foremost, they're trying to, and they care about doing justice and interpreting the law and being smart, right? And it's like, and it's their biases that are getting in the way.
Yeah, I completely agree with you, of course. It's the whole humans are persons because they are humans, right? And
Yep.
yeah, and personhood is such a multi-layered, complex concept that we can tackle through so many different angles, right? And it just becomes this flattened, and yeah, unfortunately. And Happy's cases, all those cases are so heartbreaking. So thanks for sharing that. And thank you for being here and for your amazing work, for being able to tackle this very difficult and complex questions. I think that from this conversation, I feel a little bit optimistic, maybe carefully optimistic with what you said about change. Yeah, it's something that's already happening. I see it in Brazil too. Although we have awful things happening every day, we do have some very interesting progress, and I think we need to, yeah, maybe try to remain hopeful and do our best. And again, ICARE, this initiative, yeah, it has so much potential for this change to come. And of course, ICARE's Litigating and Legislating for Animal Rights series, which we are doing today, has this very clear goal of deepening our understanding of how law evolves through dialogue, strategy, and of course, courage, like you said, Christopher, right? It takes courage from us, it takes courage from the judges, and we need to strengthen our collective capacity to drive that change. So I also appreciate everyone who's here with us today. Yeah, so once again, Christopher, thank you for sharing your experience, your insights with us, for all the work you do and the Nonhuman Rights Project. I hope you continue to advance the recognition of non-human animals as rights-bearing beings. Thank you also the audience for the very insightful questions you made. It's been great having you here. Special thanks to Maureen Lercier for organizing this, for starting this amazing initiative with ICARE. And we invite you all to stay connected with ICARE and to join us for our next seminar in the Litigating and Legislating for Animal Rights series. Until then, thank you all for being part of this growing community committed to shaping a more just legal future for all beings. So thank you so much, everyone, and have a nice day. Goodbye.
Bye, everyone. Thank you.
Bye. Thank you. Thank you so much, Chris. Thank you, Anna. Bye.